This is LightCast Entertainment. We bring you details of news in politics, entertainment, everything buzzing in the Nigerian entertainment industry, and many more. Do wait to subscribe to get updates with happenings in Nigerian entertainment scene as well as politics. Many thanks. Governor Alex Otti of Abia State has urged the leader of the Indigenous People of Biafra, Mazi Nnamdi Kanu, to remain calm and resolute as he intensifies ongoing engagement aimed at securing his release. Otti assured Nnamdi Kanu during a visit to the IPOB leader at the Sokoto Correctional Centre. This was disclosed on Sunday night in a statement issued by Special Advisor on Media and Publicity, Ferdinand Ekeoma. Otti, who was accompanied by Abia State Attorney General and Commissioner for Justice Ikechukwu Uwanna, Kanu's younger brother Prince Emmanuel Kanu, and senior officials of the Sokoto State government told Nnamdi Kanu that the process initiated more than 2 years towards resolving the issue had been heightened despite recent developments. The governor encouraged Kanu to remain calm and be strong, assuring him that the matter will be resolved administratively and he would extremely regain his freedom. He also expressed satisfaction that the Sultan of Sokoto shared his stance on the need for Kanu's release and the broader de-escalation of regional tension. Responding, Nnamdi Kanu was said to be in high spirit during the visit. He reportedly expressed gratitude to Otti for the gesture. He told the governor that his primary interest was good governance and any efforts that would improve the well-being of the people. He also prayed for God's guidance for Otti and his team as they continue to serve the state. The Abia state government noted that Kanu was all smiles during the meeting and appreciative of the renewed efforts to address the situation. Recall that following Kanu's sentencing to life imprisonment, Governor Otti had disclosed that efforts to free the IPOB leader were already underway, stressing that a release framework had been quietly activated during the trial. Kanu was in prison after being found guilty of terrorism-related crimes.
And we are going back with the memories that Sokoto is a land of hospitality. And we're happy. We're also happy to see our brother, our son, Mazi Nnamdi Kanu, who has also become your son today by reason of circumstances that happened. And we're happy that you are taking good care of him. And our prayers is that God Almighty will continue to bless Sokoto State and the Federal Republic of Nigeria for the good brotherhood and the love that we all have for each other. Thank you very much once again, and may God continue to bless us all.
Meanwhile, the Mazi Nnamdi Kanu Global Defense Consortium has declared that the Abuja Federal High Court ruling that sentenced the leader of the Indigenous People of Biafra to life imprisonment cannot survive appeal. It is expected that Kanu's lawyer will file an appeal to challenge the judgment passed by Justice James Omotosho. Kanu was scheduled to be moved by the management of Sokoto Prison, where he is serving the sentencing, to the Abuja Federal High Court for an appeal record settlement on November 28, but the court did not issue a warrant for his movement. However, in a statement on Monday, ahead of the formal filing of Kanu's appeal, the defense team explained why the judgment will not survive an appeal. Speaking on behalf of Mazi Nnamdi Kanu Global Defense Consortium, a lawyer, Barrister Christopher Chidera, described Justice Omotosho's reliance on a repealed law in the conviction as legally impossible. The team cited Supreme Court cases to sustain the argument that the judgment cannot stand. To understand how indefensible Justice Omotosho's approach is, one must look at what the Supreme Court has consistently held for over 4 decades. Once a law is repealed, it becomes dead, extinct, and no legal effect. It cannot be the foundation of a charge, trial, or conviction. This principle is not conventional. It is subject to judicial assumption without conceding. It is black letter law. Affirmed repeatedly by the Supreme Court, it said. Listing Supreme Court ruling that vaporized Justice Omotosho's approach, the statement pointed to AG Lagos State v. Odumusu 1989, noting that the repealed law ceased to exist in the eyes of the law. Further citing Nwafio versus Attorney General of Bende State, defense team held that court that applies a repealed law acts without jurisdiction. Further faulting the conviction, the defense team noted that no Nigerian court can apply the 1979 Constitution to decide a modern case, relying on military-era decree as if they were still operative, or conduct a criminal trial under the Criminal Procedure Act (CPA) because those instruments have been replaced by new ones.